In Vietnam, the labor contract is more than a simple agreement between an employer and an employee. It is the legal backbone of the employment relationship. Every right, obligation, and benefit, from salary and working hours to termination and dispute resolution, stems from this one document. Yet, many foreign invested companies continue to use generic or global templates that fail to comply with Vietnamese law. The result is that even well-intentioned employers unknowingly violate the labor code. In a country where the law values precision and documentation, one missing clause or mistranslated sentence can turn an enforceable contract into a legal risk. The foundation for all labor contracts in Vietnam lies in the labor code and its implementing regulations. The law recognizes only 3 valid types of contracts: indefinite term, fixed term, up to 36 months, and seasonal or project-based. Every employee must have a written contract, signed before work begins, except in rare cases where electronic signatures are allowed. Both parties must receive one copy of the signed document. The law also requires that the contract be written in Vietnamese or bilingual form when one party is a foreigner. Anything less than this is considered non-compliant. Many FDI companies use HR templates designed for regional or global operations, assuming that standard terms are universal. Unfortunately, they are not. Vietnamese labor law has unique rules that differ significantly from Western jurisdictions. For instance, probation cannot exceed 60 days for most positions and must be in writing. Termination requires statutory notice and valid reasons defined by law, not managerial discretion. Salary must be stated in Vietnamese dong, not only in foreign currency. Working hours, overtime limits, and social insurance obligations must also appear explicitly. When foreign employers ignore these details, contracts may be invalidated during disputes or inspections. A legally compliant labor contract in Vietnam must contain at least the following elements: 1. Full names and addresses of both parties. 2. Job title and description. 3. Workplace location. 4. Duration and type of contract. 5. Salary, allowances, and payment schedule. 6. Working hours and rest periods. 7. Social insurance and benefits. 8. Training and development obligations. 9. Confidentiality and intellectual property clauses if applicable. And 10. Termination conditions and notice periods. The law also encourages the inclusion of a dispute resolution clause to define how conflicts will be managed. Even experienced HR teams make avoidable mistakes when drafting labor contracts in Vietnam. The most common are using English-only contracts, failing to specify contract duration, omitting job descriptions, or referencing company policies that were never registered with the authorities. Some employers include non-compete clauses that are too broad and therefore unenforceable. Others rely on offer letters or emails instead of formal contracts, which hold no legal weight. Another frequent error is inconsistent translation between the English and Vietnamese versions. When disputes arise, the Vietnamese version always prevails, even if the English text says something different. Vietnamese law treats probation as a distinct legal phase. Employers must sign a separate probation contract or include a probation clause in the main labor contract. The probation period depends on the job level: 60 days for management, 30 days for skilled workers, and 6 working days for unskilled labor. If the employee passes probation, a full labor contract must be executed immediately. Employers who extend probation beyond the legal limit or fail to sign a new contract after probation will have the employment relationship automatically converted into an indefinite term contract. Renewal clauses must also comply with the law. A fixed-term contract can only be renewed once before converting automatically into an indefinite term agreement. One of the most misunderstood parts of labor contracts in Vietnam is termination. Employers can only terminate contracts for reasons permitted by law, such as repeated misconduct, poor performance, restructuring, or mutual agreement. Notice periods are strictly regulated: 3 days for probation, 30 days for fixed-term contracts, and 45 days for indefinite contracts. Any deviation can make the termination unlawful, leading to reinstatement or double compensation. Including legally accurate termination clauses is not only about compliance, it is about protecting the employer's right to manage fairly and effectively. For companies employing foreigners or operating as part of a multinational group, bilingual contracts are essential. The Vietnamese version is mandatory for legal validity, while the English version ensures mutual understanding. However, both must be consistent. If contradictions exist, the Vietnamese text prevails. Professional translation is not an option, it is a legal necessity. LTS law drafts bilingual contracts that ensure precision in both languages, bridging the gap between global policy and local compliance. LTS law assists employers across Vietnam in drafting, reviewing, and localizing labor contracts to ensure full compliance. Our bilingual lawyers combine legal expertise with HR practicality, ensuring that contracts protect both the company and the employee. We tailor each document to reflect job nature, company size, and operational needs while meeting every legal requirement under the Labor Code. We also train HR teams to manage contract renewals, amendments, and terminations properly. The goal is simple: to give employers confidence that every employment relationship in Vietnam is legally sound. In Vietnam, the labor contract is more than a legal obligation. It is your first line of defense in any dispute. A compliant contract protects your company, clarifies employee expectations, and builds trust within your workforce. If your company uses foreign templates or has not reviewed its contracts since 2020, now is the time for a legal check. Contact LTS Law today to review, draft, or update your labor contracts. Stay compliant, stay confident, and ensure that every word in your contracts works in your favor, legally and strategically.